Es lunes, so ya es tiempo de lunes de leyes. I'll be answering your questions in the immigration world. Going to go over some of the top. Ibar Malal group is live now. That's my notification. We are on live. Let's do it. Come at me with your immigration questions. Si quiere poner en español o inglés, como ustedes quieren. Voy a revisar unas preguntas que recibí ahorita y también voy a contestar preguntas en vivo y revisando las preguntas más comunes que recibe en los consultas que hacemos aquí en nuestra bella oficina 2700 Norte Central aquí en Phoenix. All right, ladies and gents, so come at me with those questions. We got the first one of the night over here that we have going on. Let me get up right here. Legal questions. Questions about the law. It was posted. I will answer questions about anything. That's not true. I'm asking legal questions. So don't come out with any other questions that are non-legal. Legal questions. Here we go. Buenas tardes. Got this one at 5:40 today. And always feel free to DM me your questions, Instamess, whatever social media platform you're on. Send it to me. Happy to respond if I know the answer. Buenas tardes. Las personas que tienen hijos mayores de 21 años y no entraron con documentos pueden someter su petición. Como siempre, los abogados tienen respuesta depende. Es la respuesta que nos enseña el primer día de escuela de leyes. Ahí yo fui a Stanford en California, lo dijeron, su respuesta debe ser depende. Y he dicho esa respuesta como 10,000 veces después de eso. So depende. So, el primer respuesta es que cada persona que tiene un hijo que es 21 años y es ciudadano americano, sí pueden meter la petición que se llama la I-130 para sus papás. Otra vez, cada hijo que tiene 21 años de ciudadano americano puede someter la aplicación I-130 para sus papás. Pero es un poco más que tenemos que explicar porque la I-130 es una forma que nada más prueba la relación. So, puedes recibir una carta bien bonito, dice approval notice, aprobado. Usted es papá, mamá de hijo, ciudadano americano que tiene 21 años. Pero no es permiso de trabajo, no es residencia, no es promesa de no ser deportado. Es nada más un papel muy bonito que usted pagó más de $500. ¿Okay? Para arreglar, por medio de un hijo que tiene 21 años, tiene que tener una entrada legal. Todos que entraron con visa y no han salido, ahí está su entrada legal. Cuando los hijos cumplen 21 años, sí pueden arreglar. Si no entró con visa, es posible todavía que pueda arreglar si había una petición metido para usted antes de 2001. Si había una petición metida para usted antes de 2001, posiblemente califiques por la ley que se llama 245I. Y si no había nada en petición para usted o para sus papás y usted tiene una aplicación, entonces el otro camino es que si usted, como si tiene DACA y salió del país y regresó con advance parole, o uno de sus hijos está en el ejército y le puede dar lo que se llama military parole in place. Ellos diciendo, yo estoy sirviendo en mi país, no quiero que deporte a mi mamá, dar una entrada legal a ella para que pueda arreglar. ¿Okay? Esas son las personas que tienen hijos ciudadanos americanos con 21 años que pueden arreglar. Todos pueden someter la petición para recibir la I-130 aprobado, pero para tener la entrevista y tener aprobación tiene que tener eso. Y también, posiblemente a veces tenemos eso, si usted tiene un esposo o mamá o papá que es ciudadano, puede usar ellos para el perdón. El hijo puede pedir usted, pero si no entró con visa, puede usar uno de sus familiares, esposo, esposa, mamá, papá, para pedir el perdón. Los hijos no califican por el perdón. Y honestamente, eso para mí es el más difícil a explicar a mamás y papás este problema aquí. Muchas piensan después de 10 años, después de arreglar, tener un hijo de 21 años puede arreglar, no es cierto. Okay? Perdón, pero tiene que tener una de las cosas que yo acabo de explicar. So thank you so much for that question. All right, another one here from Cindy. Thank you, Cindy. ¿Qué es la ley de 10 años? Algo con mucha confusión en la comunidad. La ley de 10 años. La ley de 10 años se llama en inglés cancellation of removal for a non-legal permanent resident. Okay? Eso es la ley INA 240AB que dice una persona que tiene más de 10 años en el país, tiene buen carácter moral durante este tiempo, no tiene ciertas convicciones y tiene hijos o esposa, mamá, papá, que son residentes ciudadanos, que van a sufrir extremo daño que no es usual en una deportación, puede que el juez cancele la deportación y dar la mica. ¿Okay? Otra vez los requisitos: 10 años, buen carácter moral, no tener ciertas convicciones. Y el más difícil, eso es muy difícil. Muchas piensan, pues tengo los 10 años, tengo hijos, puedo ganar mi caso. No. Hay una ley que la pone muy difícil a ganar el caso. Póngalo así. Usted tiene los 10 años, hijos ciudadanos, tiene todo ahí que yo acabo de hablar. Pero si usted y 1000 personas tienen la misma situación, un caso de esos 1000 quizás va a ganar. Pongamos 10. 10 de 1000 va a ganar. Tiene que probar esos 10 personas que su caso es extraordinario, es muy, muy extraordinario en comparación que los otros 9,990. Estamos hablando de un hijo que tiene cáncer y su doctor nada más está aquí en Estados Unidos. No hay un doctor que practique esa área en su país de origen. Okay. Hemos ganado esos casos usando diferentes argumentos. Sí es importante ser creativo. Pero lo que no quiero es que personas entren y pedir al juez cancelación o pedir audiencia con el juez cuando va a recibir un permiso de trabajo por un poco tiempo, va a tener su seguro, pero al fin va a recibir una orden de salida voluntaria o orden de deportación. Okay. Eso es la ley de 10 años. No podemos aplicar si no estamos en proceso de deportación. Si no estamos enfrente del juez, no podemos pedir eso. No podemos ir al USCIS y preguntar por la ley de 10 años. Es nada más si está en custodia del juez de inmigración. No tiene que ser detenido, puede estar afuera, pero es que tiene un caso enfrente del juez de inmigración. ¿Okay? No es imposible de ganar, pero sí quiero estar muy claro, es difícil. Antes era nada más daño extremo, pero lo cambiaron la ley para hacer mucho más difícil, para limitar el número de personas que puedan ganar. Lo pueden dar 4,000 de esos casos cada año. Es muy difícil a ganar, pero eso es la ley de 10 años. Okay? All right, RJ over there on the YouTube, thanks for hanging on, man. Cool picture. I was brought to America when I was 12. I have an engineering major. I would like to apply to DACA. My visa was stamped for December 12, 2007. Do I still qualify for DACA? So you had to be out of status on June 15th of 2007. And you're stamped in December, January, February, March, April, May. I mean, were you here before? Did you come in December of 2007? Because we might also have the problem of the continuous residence. So get at me with that one if you can, because that would be a problem. I've argued some cases and gone back and forth with them on people that were issued visas very close to the date that they must be issued or be out of status by, and it was a no-go. So get back to me on the clarification of that, when exactly you started living here. When did you start living here? We can go backwards from that. If it was December of 2007, probably not. You would qualify for the DREAM Act, right? DREAM Act would be good to go. It's only a requirement of 4 years versus this crazy DACA of being here since 2007. So hopefully we get the DREAM Act passed. Again, it's passed the House. It's in the Senate. We saw former President George Bush come out and encourage the Senate to chill out on the immigration rhetoric and pass the DREAM Act and look to more comprehensive immigration reform. So hopefully that gets us started in the right direction. Let's hope it gets us going there. All right. Thanks for your question, RJ. Now to go back to the question over here, to go the rundown in English, we are talking about the Ley de 10 años, the 10-year law. It's called cancellation and removal for a non-legal permanent resident. It only counts if you're in removal proceedings. If you have a hearing date before an immigration judge, you can ask that judge to cancel your removal because you've been in the United States for over 10 years. You have U.S. citizen children or permanent resident children, spouse, or parents, LPR, U.S. citizens, and they're going to suffer extreme and unusual, and those are horrible words, extreme and unusual hardship, and you're a person of good moral character, and you don't have criminal convictions that would kick you out of this. All right? Now, the most important part to focus on here is extreme and unusual hardship. So put yourself in a situation, if your neighbor is undocumented and they're in front of the judge, their kids are going to be depressed, their kids are going to lose out on an economic supporter if their parent is deported. Now, your case, the same thing. It's heartbreaking. It's horrible. And I encourage you to read the case law on this because you'll see they go over, oh, you're a single dad of 2 U.S. citizen kids. You have permanent resident parents in the country. Sorry, that's still not extreme and unusual hardship. That's normal hardship. So extreme and unusual, you have to show such a high barrier about why your case is different than what your neighbor's case would be if they were undocumented in order to convince that judge that you should be one of the few that gets this grant of cancellation of removal, the $4,000 that they give out a year. You have to also be in proceedings. We can't just apply to USCIS for this. You have to be in front of an immigration judge, all right? That is the law of the 10 years. And we have Rosendo, gracias, que nos está viendo en el Facebook. Aquí está en Facebook. Tengo los 245 y cuánto me faltaría pagar el permiso de trabajo. So parece que usted está protegido por la ley 245I, que vamos a explicar. Es una ley muy buena que dice si usted tiene petición puesto para usted antes de 2001, o a lo mejor sus papás, uno de sus hermanos pidió y usted está en la aplicación, que usted lo puede pedir un perdón. So el 245I da permiso que usted arregla aquí dentro del país, si no ha salido, si ha quedado aquí, y usted tiene que pagar una multa de $1,000 con su aplicación. Es igual que como tener una entrada legal, que entrar con visa, ¿verdad? Eso es la protección. So, no hay un permiso de trabajo que viene con la aplicación 245I. Es nada más como una entrada legal, puede pensarlo, y cuando usted tiene alguien que puede pedir, puede usar eso como una entrada legal. Si tienes una petición de hermanos que todavía está esperando, es igual. Usted no va a recibir permiso de trabajo mientras que está esperando su fecha. Es nada más esperar, esperar, esperar. Y cuando llegue esa fecha mágica, usted tiene que mandar la aplicación para que pueda arreglar. Y ahí, después que mandamos un paquete de residencia todo junto, muchas veces antes pandemia recibimos un permiso de trabajo 3 o 4 meses después que mandamos la petición completa. Pero tiene que tener una aplicación de residencia ya disponible, su fecha tiene que estar disponible para que mandamos. Okay? So that is the question about 245I. 245I is a great law. It's kind of like a switch for a legal entry, right? If you came in with a visa and your 245I, you're still going to want to use a visa entry because the 245I has a $1,000 penalty fee with it. 245I is a huge benefit for those that came into the country without a visa. That means they can still adjust here in the country if they have an immediate relative or if their visa is current on a petition that's previously been put in for them. A $1,000 penalty fee you got to pay, and once your day is available, Then you can send off your packet. Then you'll get the work permit. The hopefully interview and the residency card comes after that. That is the Law 245I. Hopefully we can bring something like that back. All right. And RJ had some more info for us. Came to America in December. I was a tourist only before that, but in 2005 we started living here in December 2007. Yeah, I mean that unfortunately we got a show before June, so I don't think we could get the DACA for you, RJ. And again, I hate to sound cold-hearted, and I'm just like spewing stuff out. A lot of what I do on a daily basis is just telling people bad news. My least favorite part of being an immigration attorney is the immigration system itself, is the limited amount of laws that we have to actually help people. Here's a prime example right here. But let's get that DREAM Act passed so we can get you something better than just a work permit and get you the full-on path to citizenship. That's what we want to see, all right? And always, folks, if you have any other questions, it doesn't have to be just about immigration. We also practice criminal law, federal criminal, state criminal, DUIs, personal injury, car accidents, wrongful deaths, all that kind of stuff. Feel free to drop those questions down as well, all right? So feel free to drop in more questions. Of course, man, my pleasure. And again, let's get the DREAM Act done so we can actually help you then, man. That's what I'm looking forward to. So we had the question earlier, which I neglected to respond to in English. I apologize. But this was about if someone has a U.S. citizen child that turns 21, can they automatically make their parent a resident or a citizen? And the answer is depends, right? It depends because whether or not the parent came in with a visa or whether they came in through the desert is normally the deciding factor if we can do it or not. Someone that has a legal entry into the country, and there's a case on this right now at the Supreme Court about whether or not the Supreme Court's going to honor an admission, a TPS as admission. But what you have to know for right now is if you came in with a visa, you have that admission, you haven't left, you're still good to adjust in the country. If you came in what they called EWI, enter without inspection, through the desert, walk for 3, 4, 5 days, you don't have that legal entry, you can't adjust in the country. You would need the waiver. Everybody's heard about the waiver, right? El perdón. So the waiver, though, you can't get just for kids. You have to have a spouse that's a citizen or a resident, or you have to have a parent that's a citizen or a resident. Make sense? Not really. That's why immigration law is so tough. It's not really logical. It's just the way Congress decided to write the law. So unfortunately, someone that doesn't have a legal entry would have a hard time adjusting, even if their kid turned 21, unless they have a legal entry, unless there were 245Is we discussed earlier, unless one of their kids was in the military and they got military parole in place, or unless they had DACA and they were able to get advanced parole through DACA. All right, so that's the way to adjust through residency, or through a 21-year-old U.S. citizen child. And again, that is probably the most heartbreaking consults that I have to do. Literally have people that walk into the office here with their money that they've been saving for years, ready to adjust, right? How much money do I need, attorney? How much do you charge me? How much is the government fees? And I have to ask them the questions first, break it down and say, I'm sorry, we can't do it right now. That's the way the laws are set up. It's not advantageous to us to be able, as it should be. Someone's been here 20 years, no crimes, paid their taxes, raised amazing children, given back to the community, no legal entry, no adjustment of status. All right. So keep coming, ladies and gentlemen, with your questions in the criminal, immigration, personal injury world. Always happy to answer them. The most common consults I've been doing the past couple of months is marriage. Marriage, right? So if you are DACA and you marry a U.S. citizen, or if you're undocumented and you marry a U.S. citizen, there's also a lot of myth like within a week you'll have your residency, then your citizenship, super easy. Not that easy, right? And the most complicated to understand are folks who are trying to bring someone from out of the country because they just don't comprehend how long it takes. We're talking perhaps a year and a half, 2 years, especially with COVID right now, to get someone into the country. Let's start with the people that are here in the United States, right? We'll set you an example. Someone entered without inspection. They're now living and they marry a U.S. citizen. What can they do to become a legal permanent resident? It starts with that I-130 that we talked about with the parent petition that proves the marriage is valid. And that's going to be an 8 to 14 month process. You have to submit proof of the marriage, certificate, birth certificate of kids, photos, letters, all that good stuff. Probably get an interview. You have to go there, answer the questions, be all nervous if they're going to approve you or not. And then once that gets approved, if the person does not have a legal entry, they must then ask for the waiver, el perdón. So we got to send the waiver off. We got to prove extreme hardship to the U.S. citizen spouse. Maybe send the person to a psychologist. They were going to suffer some depression. If the person's deported, send off the medical records. And a whole nother video just on the waiver we can do. And when that waiver gets approved, which hopefully it does, you can then set yourself for an interview in Ciudad Juarez or your country of origin, where you go and they determine whether or not you're admissible into the country. None of these steps are guaranteed. I-130 is not guaranteed. The waiver is not guaranteed. Coming back from Juarez isn't guaranteed. You got to make sure that when they ask you the questions they're going to ask you, you answer them the right way. Right? Never used drugs, never been here longer than a year, then left and come back. Lots of little nuances there. And that is, in a nutshell, consular processing, the waiver process through a U.S. citizen. All right? And Laura, gracias porque nos está viendo en Face. Muchísimas gracias. Tenemos más preguntas aquí. Let's see what we got going here, folks. We got some questions. And let's see here. So, IR5 process and MVC, all steps ready, just waiting for an interview. Could expedite work, petitioner's getting surgery, needs care for child well-being and surgery. So this is, you got a lot of acronyms in there. We're gonna have to break this one down, all right? So we have a relative petition at NVC, which stands for the National Visa Center. That's kind of our equivalent of USCIS, but if you're out of the country. So if you're out of the country, you're going through the National Visa Center. If you're in the country, you're going through USCIS to get your papers, National Visa Center to get somebody here. So they're waiting for an interview, which is incredibly slow and difficult right now. I want to throw something at the camera because we have people that deserve to be with their families now, that cases have been approved, and the interviews are so unbelievably slow to get. So can we get it expedited if petitioner is getting a surgery and needs care for child well-being and surgery? That to me sounds like a really great argument to try to get a humanitarian request to the Department of State to get a quicker interview to get them over here even faster. So I would definitely reach out to MVC, have supporting documents, letter from the doctor, medical diagnosis, all that good stuff, and pressure, pressure, pressure. Cases like this, I would also recommend getting involved your federal senator or your congressional representative, asking them to write a letter, asking them to intervene as well to try to get the case moved up for the humanitarian reason. So yes, make that happen. And you are the petitioner, and I'm sorry to hear about the child. Hope everything turns out good. From the bottom of my heart, best of luck to you. This is that cruel, horrible immigration system, but you keep fighting it, and the squeaky wheel gets the grease. So keep making that noise, make it happen, get him over here. All right? Angel for DACA. Oh, I missed the first one, Angel. Sorry about that. How long after getting the notice of receipt from USCIS does it take to get biometric appointment if filing for the first time? So Angel, congratulations if it's you or if you're helping somebody. Great to see, man. That is pretty awesome. So once you get the receipt, it's going to be only a matter of weeks. I know I made a call on Friday to someone that got scheduled for an interview next Friday, and I think we sent theirs off in January, and it did take a while for the receipts to come back in. So that one took a lot longer, right? So it is possible that it could take a month or 2 months. Depends on your jurisdiction. We have DACA cases from New York to Texas to New Mexico to California. So each location will have a different amount of time. The best thing to do is to take that receipt that you have and you go to USCIS case status and you can go on there, you put the receipt number in, LIN, bunch of numbers, pop, and it'll tell you what the latest in your case is. So before you get it in the mail, it'll come to you. As long as you have your mailing address correct, you got the receipts, deep breath, wait for the process to play out, keep checking online. If it says they mailed you something and you didn't get it, then you start, panicking and taking the actions of contacting them and saying, hey, I didn't get it. But for now, you should be good. All right. Oh, we got some inside info here. I've heard they're going to vote on DREAM Act in Senate as soon as late this month or early next month. Is this true? I'm just going to take your info as the inside info because I don't know. Nobody's told me. It's gone pretty much mum is the word. George Bush's article on Sunday hopefully will hit some strings within that Republican Party. He goes over how one of his biggest defeats or regrets of his presidency is not getting immigration reform done. And guess why it didn't get done? Because he couldn't get enough of his own party, Republicans, to get over the filibuster. Guess what problem we're having right now in 2021? We can't get enough Republicans to get on board to get over the filibuster. So maybe you get rid of the filibuster. Problem solved. Change some lives. Do some justice. Legislate. Lead. Your ball is in your court, Senate. Make it happen. All right. Maria says, what's the likelihood for humanitarian parole to be granted and the approximate wait time? I looked up the wait times the other day. I think there was, and you can look this up on any case. You can Google USCIS case processing times. Takes you to their website. You put in the form and the application support center was sent to. Bam. Like magic comes out the wait time. Last I checked last week, I think it was in the 4 to 8 month range, depending on which processing center you send it to. So say 4 to 8 months. And the likelihood of getting granted all depends on the strength of your reason, the strength of your application. And the most common one we've been seeing lately is sick relative, sick grandparent that you have to go and take care of or see. And those have still been getting positive grants from what we've been seeing. So hopefully you got a great argument there to convince them. You have it well documented and they give you that approval in 4 to 8 months. You can get them expedited, kind of what we talked about earlier. If it's like an emergency, funeral or something, then those will come in quicker. But for the normal ones, last I checked was about a 4 to 8 month range. All right. Filed March 1, Angel says, in the great state of Arizona. Viva Arizona. I think you still have a little bit more to wait. I don't think we've gotten any fingerprint appointments for anything we sent early March just yet. So your case is probably still on track. Not much to worry about. All right. And of course, my pleasure. Thanks so much. YouTube representing well tonight. If you're watching on YouTube, do me a favor and go over and hit that subscribe button. If you're watching on Facebook, do me a favor and go over to YouTube and hit that subscribe button. Trying to get to the magical 1,000. We're at about 830 right now, so greatly appreciate that. Y como siempre, comunidad, si tienen sus preguntas en inglés, ponga abajo. Si tienen español, ponga abajo. Otro idioma, probablemente yo no sé. Pero inglés o español sí puedo contestar. Okay? And here it was. Yep, sick relative humanitarian parole is humanitarian count as lawful entry for adjustment of status process. So Maria is asking if that humanitarian parole through DACA, when she comes back, will count as a legal entry. The answer today, April something of 2021, 19th of 2021, is yes, right? Advanced parole through DACA will count as an admission. The law is changing all the time, but as of today, we can still say a positive yes to that. I would have no problem submitting one step, we call it application, if someone had DACA advanced parole and made it back into the country. All right. And so that's good news for right now. So keep off sending off those DACA initials as Angel, our friend's doing. Best of luck to you, Angel. Keep sending off those advance paroles. Sounds like Maria's doing or know somebody that's doing. And keep advocating for the DREAM Act. Nothing more important to do right now than to make sure we get that taken care of and get that passed. Another thing that I'm annoyed about is we've yet to get back admin closure in the immigration court. So I'd like to follow up with the Biden administration and see what's going on with that. And that is some crazy stuff going on. We thought Biden comes into office, come back into power, we'd be good to go, be back to the same fight we had under Obama. It's not even there yet. A lot of things to work on, a lot of things to change. Let's get it done. All right. When is the Excluded Workers Relief Bill of New York going on effect? The news says it's already passed and signed by Cuomo. How can undocumented people in New York apply? Awesome question. I do not know, unfortunately, but something I'm happy to look into for our family members over there in New York and get something out on, because states doing positive things for immigrants is something new to me since I've been in Arizona pretty much my entire life, except for a few years in law school, because this state is absolutely ridiculous towards immigrants, right? And William, in case of a new law passing on Congress, someone that came with a B1, B2 and overstayed, did 6 years taxes, got a high school diploma, would have any chance? Absolutely, William. First off, it's called Match.com. All right, so you go to Match.com, you put in whatever your type is, whatever your love is, bam, you find that person who's a U.S. citizen, you fall deeply in love, it's a real love, you get married, and because you entered with a visa, you don't have to wait for the stupid Senate to do anything. You can just adjust status. Now, you don't want to do that, marriage is not your thing, then we need the DREAM Act passed. The fact that you have the high school diploma, that you've been here over 6 years, because you've done taxes for 6 years, means you would qualify for the current version of the DREAM Act that's passed the House or the one in the Senate. So I'm very confident that that would be a way that you could adjust to. Coming in with the B1, B2 is just positive if you wanted to adjust, not negative at all if the DREAM Act gets passed. All right? And here we go. Oscar, thanks for tuning in on YouTube there, my friend. 2 entries will be a problem coming back to the country with advance parole by DACA. If you have an advance parole, it's granted for a certain period of time and for multiple entries, I still don't think it will be a problem. It's like a fictional, you didn't really leave, but you get a legal entry. So as long as you're coming in and out with that grant of advance parole, I'm not worried about it's 212A9B, 212A9C, because you're leaving with permission, you're coming back with permission. I don't think that would kick in. So I don't have a problem. I've heard some people with the theory, that they have a problem with the multiple entries. I don't. I just don't think that USCIS would come back and say that's the intention of that law, to get people that left with a legal approved entry. All right. And I'm sorry, let me go with this one first, Oscar. To EWI entry, yeah, we're a different ballgame now. We're talking about EWIs, yes. So EWI means entry without inspection. Now what we have to do here is we got to do a very careful timeline. We got to look at what year the person came in, what year they first left, what year they came back, what year they left, what year they came back. That math, advanced level calculus, is going to determine whether the person's okay, don't worry about it, or you know what, you shouldn't move anything because you're going to get hit with a C bar, which is when you're over here for longer than a year without status, you leave, you unlawfully come back. That's very bad news. Those are the kind of calls I get from someone in Ciudad Juarez, not our clients, but somebody else's. The paralegal who used to work for immigration told me I'd be fine. But I went to the interview and they said I'm here for 10 years. So yes, anytime there's multiple EWI entries, we want to do the complete math on it and review it entirely before we submit anything to immigration. Now DACA, DREAM Act, not necessary that's going to necessarily, is that going to be a problem? We'll have to see the final rendition of it because that's not necessarily something that they were too concerned with as they were in '96 when they put these crazy laws up. All right. And can undocumented people file taxes and how? Yep, it is called ITIN. So you request an ITIN number from the federal government. With that ITIN number, you can file your taxes, and that is the way to do that. All right. Well, ITIN, ITIN number if you have a business. EIN, right? An EIN number, or an ITIN if you have a business, but an EIN number and an ITIN number are the two things that I'm confusing. So get one of each. All right. Before advance parole, yeah, that's scary, Oscar. That's scary, honestly. Like, even leaving, because every time you come in, they can inspect you whether or not you should be admitted. I'm not doing advanced paroles for folks that have multiple entries before. I just think it's a big risk of running into the wrong CBP officer. Haven't seen it happen before. To me, it just makes me nervous coming back and forth. But again, before 96, we might not have an issue. So it depends on the time frame of when those were. But it would make me nervous setting someone out on advanced parole that had other grounds of inadmissibility and other reasons they could be put into proceedings. That gives me a bit of caution. All right. And so that is what we've been talking about. And yes, it is an ITIN, right? Not an EIN. EIN's for businesses. My apologies on that. So keep coming, ladies and gentlemen, here. Questions, comments, concern in the world of expectations. William giving us an insight. More hopes and expectations in Congress than going to that website. Hey, man, you know, that's the way it is. That's the way it is. So let's just get the DREAM Act passed. Easy and simple. You ain't got no pay no money, no websites, do none of that stuff. We just get the DREAM Act passed, and let's make that happen. And let's get everybody on the path to citizenship that we have been waiting for over 20 years for. 20 freaking years. So ahí está, comunidad. Si tienen más preguntas, comentarios, pongan abajo. Si no está viendo en vivo, de todos modos, puede poner comentarios, preguntas, y puede ir a YouTube y poner el button de subscribe para que nos pueda ser notificado cuando hay un video nuevo, por favor. All right? And am I required to file taxes even if I'm undocumented and working on cash salary? Can there be a penalty if I don't file taxes? This is going to depend on the final bill that gets approved if we're talking about the DREAM Act, right? My guess is telling me Republicans are probably going to come back with some demand for a multi-year taxes haven't been filed or taxes get filed before someone can apply. The good thing about this is, and I'm not an accountant, so I can't give tax advice, and you don't want my tax advice anyways. You want my legal advice. So you can always go back and refile taxes if the law passes and it comes out saying, oh, we need 3 years, 4 years of taxes. So not necessarily anything I think they're going to punish if you hadn't done it yet. I think you would go ahead and wait to see what the DREAM Act, if it passes, what it ends up saying. And hopefully it gets passed, so we have that problem, right? Oh, heard rumors, William, maybe the end of the month, maybe next month. I haven't heard anything. It's just been complete radio silence about what they're planning, what they're actually going to get done. But hopefully they're still moving back there behind the scenes to get something to us before the summertime, which is what we were guessing when it first passed the House. Right? So let's continue to hope for that and look for that to happen. That's Lunes and Leyes, ladies and gentlemen, 7:41. I got people sending me messages as well, which you can always do because I'm not going to read your private messages up here unless you give me permission to do so, because there's not oftentimes information you don't want to give publicly, and I'm happy to take a look at that. So feel free to DM me as well. And if it's not something you don't mind sharing with the world, feel free to drop it below in the comments. And I will do my best, as always, to answer. And if you need a private consult, you got the number right there. You said text away, it's a call away, 602-910-4040. I'll take a look at your entire case and see whether or not we can make something happen, which hopefully we can. It's been a crazy world right now, ladies and gentlemen. Got the George Floyd killer, Derek Chauvin, on trial. Case has been submitted to the jury. I'm nervous. I mean, you know, what is a jury of 12 folks going to do? The whole world knows he's guilty. The whole world knows he should be found guilty. But when 12 people get in a room and they don't have the benefit of watching the replay constantly and seeing what's going on in the world surrounding the case, you don't know what the answer is going to be. And we have Phoenix City Council tomorrow. If you're available, the last budget, reach out to Poder, follow them, Poder en Acción, and see how you can get involved on the budget issue there, City of Phoenix Police. And let's hope for a guilty verdict in the Chauvin trial. All right. Thanks so much, everybody, for tuning in. Look forward to seeing you on the next Lunes and Leyes. We'll be back on Thursday for the Thursday Facebook Live as well. So please tune in then. Until then, like and subscribe. Get me over to 1,000. Much appreciated. Have a great night.